Good afternoon, everyone. This is Chris Hartsacker from IAB Europe. Welcome to our second webinar in our GDPR webinar series. Today's topic is the definition of personal data under the GDPR. It's something that we also have a working paper on, which you can find on our website. And we're very pleased to have Geeta Harris-Newton from Quantcast here. She's their Chief Privacy Officer and Deputy General Counsel. And she also authored the paper that we have on this topic already and led the work internally on that. So we're very pleased to have her here to talk about this. And the format is going to be first a presentation from her, and then at the end there will be an opportunity to write questions in the Q&A section on WebEx. And we will try and do our best to answer all of them, assuming that we have the time to do that. So without any further ado, Geeta, the floor is yours.
Thanks, Chris. Hi, everybody. So let's talk about personal data. For our agenda today, we're going to first address why personal data, why do we care about personal data as a subject, and then talk a little bit about what is personal data. And to do that, we're going to go to the GDPR and look at the definitions that we find in the GDPR and examine a few types of data that are outlined in the GDPR, so personal data and sensitive data, anonymous data, and pseudonymous data. We're also going to look at what this all means after we take a look at those definitions. What does it mean? And talk about some things like, online identifiers and whether those are personal data, about online advertising and whether it singles out individuals, and look at some examples. And then, as Chris said, we have lots of time reserved for discussion and questions and answers. So first issue before us, why does personal data matter to our discussion? Well, it's because the GDPR regulates personal data. So Article 1 of the GDPR tells us that the GDPR applies only where personal data is at issue. So if the data that you are concerned about is not personal data, GDPR doesn't apply. So it's a fundamental issue that we need to look at when thinking about what is regulated by the GDPR. So this is a little fun slide just to ask yourself the fundamental question of whether GDPR applies to your company. So, starting with, does my business process data? If no, then GDPR does not apply. Is that data, if you do process data, yes, then is that personal data? If yes, GDPR applies. If no, well, it doesn't apply, but what we're going to talk about in this webinar is why you might need to go back and ask the question again. Because very often what you'll find, as we'll talk about today, the data that you process very well may be personal data. And also just something to remember, I think in the online context we often talk about personal data in relationship to consumer data or users that are browsing online, but I think it's important to remember when you're asking these questions about whether your company is processing personal data, it's important to remember we're not just talking about consumer data. You also need to consider things like employee data, which may be personal data, or data from your partners that they share with you. So let's look at the question of what is personal data. And to do that, I've taken this language directly from GDPR. And the orange emphasis that you'll find in this slide emphasizes the changes from the Data Protection Directive to GDPR. So we will look at this because I think it's important to actually understand what the text says. And then, as I mentioned, we'll go through the text of the GDPR in a number of instances, and then we'll unpackage it a little bit after that. So personal data means any information relating to an identified or identifiable natural person. That's the data subject. An identifiable natural person is one who can be identified directly or indirectly, in particular by reference to an identifier such as a name, an identification number, location data, an online identifier, or one or more other factors. So it's important to remember that when thinking about personal data, we're talking about information that's related to a person, and that person can be directly or indirectly identified. They can be identified or identifiable, and you can do that by referencing an identifier. So not just a name, but also something like an ID number or an online identifier or other factors. So remember that new to this definition now is this explicit reference to online identifiers and location data. Looking a little bit more at what the GDPR says about personal data, if we look at recital 30, which is here, sort of further expanded these references to online identifiers in this recital. So here you've got references specifically to IP addresses, cookie identifiers, RFID tags in particular, and it talks about which, these leaving traces when combined with unique identifiers and other information may be used to create profiles of natural persons and identify them. So again, it's this idea that online identifiers might be combined with other information to create profiles and make an individual identified or identifiable. So also looking a little bit further at what GDPR says specifically about personal data, we have recital 26 and a couple of ideas here. The language specifically in the recital talks about when you're trying to determine whether a person is identifiable, you should take account of all the means reasonably likely to be used, such as singling out either by the controller or by another person to identify that person directly or indirectly. And when thinking about what means are reasonably likely to be used to identify the person, you have to take into account all objective factors, such as the cost of an amount of time required for the identification and taking into consideration the available technology. So there are a couple ideas in here that we'll come back to talk about in later slides, but this idea of singling out a person as being linked to personal data, and this other idea of using all the means reasonably likely to be used by a controller or by someone else, and considering all these available factors. So we'll come back to those ideas in later slides, but just to show you where those ideas come from in the GDPR and this recital 26. So the keys to take away about personal data are that under GDPR, the definition of personal data now explicitly includes online identifiers like cookie IDs and location data, which were not explicitly called out in the Data Protection Directive. And it's also important to remember that it's a piece of data is personal data if all means reasonably likely to be used could result in either direct or indirect identification. So let's also talk about a special category of personal data, so sensitive data. And this is not something that's new to GDPR, but it's expanded again a little bit in GDPR. So here's the definition that comes from Article 9 of GDPR. And again, here in orange, you have the highlights that are new to GDPR. So it's the emphasis on the new language. So sensitive data is personal data revealing racial or ethnic origin, political opinions, religious or philosophical beliefs, trade union membership, genetic or biometric data, or data concerning health, sex life, or sexual orientation. So we're not going to talk about these special categories of personal data in any detail today, but I wanted to point it out to you just so that you keep in your mind that these special categories of personal data do get special protection, and generally, if you're going to collect and process this data, you're going to need explicit consent from the data subject. We won't focus on that here, but just to point it out to you. And so again, the key behind special categories of personal data, also sometimes referred to as sensitive data, is that very similar to the Data Protection Directive, but now explicitly included in the definition are genetic and biometric data and sexual orientation. And so the other key takeaway for you is that if this is a type of data that you collect, you need to consider treating it with particular care. So in continuing sort of our look at GDPR and what the text says, let's think about anonymous data. So anonymous data is interesting because it's a type of data that's not covered and not regulated under GDPR. So anonymous data, as we see here in recital 26, is data that cannot identify a natural person directly or indirectly. So the person is not identifiable from the data or using reasonable means to try to identify them. It's really the opposite of personal data, and it's not regulated under GDPR. So if you have anonymous data, GDPR doesn't apply to it. One example you might think for anonymous data is when you think about aggregated data that doesn't have any identifiers associated, but a pool of data without identifiers would likely be aggregated data and anonymous, and therefore GDPR doesn't apply. Looking a little bit deeper at anonymous data, we can look to the Article 29 Working Party's opinion on anonymization techniques. So this is back from 2014, before GDPR, but still applicable and still provides some insight. And here you can see that the Article 29 Working Party talked about anonymization as a process, a technique applied to achieve irreversible de-identification. And I think it's helpful to think of anonymous data in kind of two different ways of being anonymous. One is that you can have personal data that's gone through an anonymization technique. So it's personal to start, but you anonymize it, and what you're left with is anonymous data, and that's what this language here from this Article 29 opinion talks about. But you can also have anonymous data that is simply anonymous by its nature and anonymous when you collect it. Both are important, and your company may approach anonymous data in either way or in both ways, so it's important to keep both in mind. But the key takeaway, again, for anonymous data under GDPR is that there is no change in definition, and anonymous data is outside the scope of GDPR. So let's also talk about one more category of data, and that's pseudonymous data. This concept of pseudonymous data is adopted in GDPR, and it was not contained in the Data Protection Directive, so it's new. Pseudonymous data is a type of personal data. And over the next few slides, we'll see the language in GDPR that talks about pseudonymous data. But let's start here with Article 4, which talks about pseudonymization as the processing of personal data in such a manner that it can no longer be attributed to a specific data subject without the use of additional information, and provided that that information is kept separately and subject to technical and organizational measures to ensure that the data is not attributed to the identified or identifiable person. So this idea of pseudonymous data is particularly important, I think, because many technology companies in the past have considered pseudonymous data to be outside the scope of the Data Protection Directive, outside the scope of personal data before GDPR. And so where I think there was sort of a split of thinking between different people depending on who you ask. Some might tell you that pseudonymous data was not personal data regulated by the Data Protection Directive, and some might tell you that it was, in fact, or is personal data. I think under the GDPR, now we can see in writing that under the GDPR, pseudonymous data is, in fact, a type of personal data. So let's look a little bit more at what is pseudonymous data. Recital 26 goes into it in a little bit more detail and talks about the fact that additional information is, when you have pseudonymous data, additional information is needed to identify the person. And if the person is therefore identifiable, or using all the means reasonably likely to be used, such as singling out, the person may be identifiable, then the data is in fact pseudonymous and therefore is personal data. So remember, this is going back to those ideas that we heard earlier, that you must consider all of the means reasonably likely to be used to identify. And a little bit later, we'll talk about one or more examples of what types of means those might be. Here again, just to sort of round out the language from the GDPR on pseudonymous data, on these next two slides, we really start to see a little bit about the incentives to pseudonymize data. So recognizing the benefits in Recital 28, you see that GDPR talks about the fact that applying pseudonymization to personal data can reduce the risks to the data subjects and also help the data controllers and processors meet their data protection obligations. So it is a positive thing as recognized in GDPR. And Recital 29, again, goes further, talking about creating incentives to applying pseudonymization. which allowed general analysis of the data, and that might be possible within the same controller when that controller has taken those technical and organizational measures and kept the data separately. So that means within one controller you may have personal data which is not pseudonymous, but you may have a separate database which contains pseudonymous data, and it is pseudonymous because you have technical and organizational measures to prevent those two data sets from being matched, and they're kept separately. So again, we're seeing language in GDPR about some of these benefits, and then on the next slide we have some additional and similar language from Article 6, for example, talking about the existence of appropriate safeguards. So we're processing data for purposes other than for which it was originally collected. The controller can take into account the existence of appropriate safeguards, which might include pseudonymization. Article 89, again, talks about safeguards like pseudonymization when processing for archiving in the public interest or scientific or historical research purposes or statistical purposes. And then again, Article 25 comes back again and talks about the need to implement appropriate technical and organizational measures like pseudonymization in order to have data protection and design by default. So the key here really in pseudonymous data is that the GDPR introduces this concept of pseudonymization where we didn't have it contained in the directive previously, and makes it very, very clear that this is personal data. So pseudonymous data is personal data, and then that there are benefits to pseudonymization. So there are incentives. Incentives for controllers are that, as we saw little bits of here, pseudonymizing data may allow for processing beyond its original purpose. It may allow for scientific, historical, and statistical research. It's a security measure. And additionally, some data subject rights might not be required when you have pseudonymous data where you're not able to identify directly the data subject. So the next slide is really just to give you a bit of a visual of the data protection framework. So you have here the green data, which is personal data and regulated by GDPR. And then as you go further out, you get the blue data, which is anonymous and not regulated. But within the green, you see this concept of PII. So what in other jurisdictions, folks often refer to as PII, so personally identifiable information, is a type of personal data for sure. But what you can see is that PII is really this smaller circle of identified information, but the idea of the concept of personal data goes much beyond that to include information that is where an individual is identifiable. So that includes pseudonymous data, as we were just talking about. So that's kind of the background of the text of GDPR itself and what it says about personal data and these different types of data. But what does that really all mean? So let's, as I said, unpackage that a little bit further. I think one of the big questions on folks' mind might be, are all online identifiers personal data? And the answer that I have is no. But the real key question is where to draw the line, because as you saw from the language that we just looked at, it's not always crystal clear. And one of the big questions, I think, for IAB Europe, for the companies listening to this webinar, and for the membership of IAB Europe, one of the key questions to ask is, can the ad industry make meaningful use of identifiers that fall outside of the scope of GDPR? So we talked about anonymous data falling outside the scope of GDPR, but then we talked about what does fall within the scope, such as pseudonymous identifiers that are often used by the ad industry. So it'll be interesting to think about and to discuss. I hope we can discuss with questions and answers on this call whether the ad industry can look outside of the context of personal data. So let's take that first question that we looked at on the last slide, thinking about, are all online identifiers personal data? Because remember that when we saw the definition of personal data, there were explicit references to online identifiers, both as a category and including things like cookie IDs and IP addresses. Well, as I said, my view is that all online identifiers might not be personal data, and I think that the UK ICO has taken a similar position. So The UKICO is the data protection authority in the United Kingdom, and last January they issued some guidance, their overview of GDPR, that left open the possibility for use of identifiers that are not personal data. So the language here in the second bullet comes directly from the UKICO, and saying that the GDPR applies to personal data. However, the GDPR's definition is more detailed and makes it clear that information such as online identifiers, for example, IP addresses, can be personal data. So to me, the important word here is can be personal data. The UKICO doesn't say that in every instance it always is personal data, but says that it can be. It also talks about personal data that has been pseudonymized can fall within the scope of the GDPR, depending on how difficult it is to attribute the pseudonym to a particular individual. So again, it's this concept of, yes, pseudonymous information can be personal data, but it's really dependent upon the context, and in this case, how difficult it is to attribute the pseudonym to a particular individual. So continuing on this same line of thinking of are all online identifiers personal data, a helpful way to think about it is this concept of singling out. This concept of singling out is contained in GDPR, and we saw that in one of the earlier slides when we were looking at the recitals. But we can also, and you can see it here on this in recital 26, where there's language around, in determining whether a natural person is identifiable, because remember, a person can be identified, like by their name, or they can be identifiable with additional information. You have to take into account all the means reasonably likely to be used, such as singling out. And so this concept of singling out isn't new to GDPR. We've seen it from some of the Article 29 Working Party opinions in the past, the ones that predate GDPR. So if you look at the Article 29 Working Party opinion from 2007 on the concept of personal data, they talked about this concept of singling out, and that when an identifier is used to single someone out, it is personal data. And this quote comes from that opinion: the mere hypothetical possibility to single out the individual is not enough, but you must take into account all the means likely reasonably to be used by the controller or another person. So as we saw in the earlier slides, this language that was used by the Article 29 Working Party in 2007 is really very similar to the language that was ultimately adopted in GDPR. We can also look back at the Article 29 Working Party opinion in 2010 on OBA, which again talks about this idea of singling out. OBA often entails the processing of personal data, that opinion says, because IP address and unique identifiers through cookies enable data subjects to be singled out, even if their real names are not known. So again, it's the same concept and this idea of singling out. And the way I like to think of singling out is that if you think of a crowd of people, if you can sort of pick one person out of that crowd and follow them, even if you don't know their name, that's personal data. So if you think of a group of people browsing a website, and if you can single out one of those browsers, even if you don't know particulars about that individual, like their name or their address or their phone number or email address, but if you know enough to be able to track them across websites and across time, then you've been able to single them out, and that's personal data. Another good example comes from the Breyer decision that came out of the Court of Justice last year, and that was a decision where a website operator collected dynamic IP address, and the court found, and so dynamic IP address, if you're not familiar with it, means that every time that particular browser starts a new session and comes back to the website, a new IP address is shown for that browser. So it's not the same sort of across time. But the court held that dynamic IP address is personal data if the website operator has the legal means which enable it to identify the data subject with additional data. So in that case, the website operator had the legal ability to compel the ISP to provide it with information that would allow it to identify the individual. And so the court found that because the website operator had that ability, that legal ability, the dynamic IP address is personal data within the hands of that website operator. So that case really, looked at all the means reasonably likely to be used and reinforced this idea that you have to consider all the means reasonably likely to be used. Here, the website operator had the legal means, even though the website operator didn't have the information in its own hands, but the court found that nonetheless it was personal data within the hands of the website operator. So one thing to think about here, as we've talked about singling out and we've talked about online identifiers as personal data, does behavioral targeting single out by definition? Is the point of using cookies and IP addresses as identifiers so that those in the digital advertising ecosystem can track consumers across sites? And if you do that, is that then singling out by definition and meeting the definition within the GDPR of personal data? One interesting thing to think about is, well, what if you could never tie it back to an identifiable person? What if you never could tie it back to an individual? So when we saw in that Breyer case, they're using all the means reasonably likely to be used, the website operator had the ability to tie it back to an identifiable person. But what if there's an instance where you can't? So let's take a look at an example. And we'll use IP address as an example over the next 2 slides. We know that if data can be re-identified by a controller or by another entity, it's personal data. So we're taking Matthias's example here. And the first example across the top line, looking at IP address, is the example we just talked about in this Breyer case. So you have a website operator collects an IP address when someone comes to use their service. They then would have to use the legal means, in this case perhaps a court order, to go to another company, in this case the internet service provider, in order to find the information of this person's name, which would allow them to directly identify this individual. And what we saw from the Breyer decision is that in this case, that IP address is personal data, even in the hands of that website operator who's providing the online service. If you look at the second line for a second example, what you have here is sort of a more direct route, which you might think more clearly illustrates personal data, and that's you have the IP address collected directly by the internet service provider, the IP address collected directly by the ISP, and the ISP within the data that it has knows that this is an individual and has the individual's name, so that is clearly personal data. If we look at the next slide, let's get into some more nuanced cases, because as in the last slide, we said if the data can be re-identified by either the controller or another entity, then it is personal data. But let's think about the opposite case. So if the data can't be re-identified by the controller or by another entity, then it's not personal data. So let's take an example of a Wi-Fi hotspot. So what if I am in Heathrow Airport and I'm on a free Wi-Fi hotspot, and the website operator in this case collects my IP address, but I'm sharing this IP address with 2,000 other people who are also on that hotspot and using the same IP address. So then is that personal data? Or what about the case when a service provider or a controller collects only a truncated IP address? So the only identifier they're collecting is a truncated IP address, and a truncated IP address isn't unique to one individual because it has some of the octets removed from the end of the IP address. So it makes that IP address common to a lot of other people. Well, is that personal data? And I think the answer here really is that it's a context-specific analysis. It's case by case. So it depends on the circumstances around what IP address is obtained, the purposes for what it's going to be used, and who receives it. What if the holder of the IP address has additional means to identify? So in this example of the Wi-Fi hotspot, well, what if that common IP address is collected, but what if the controller who collected that also collected additional information from me? So what if when I filled out a form to allow me to use the free Wi-Fi hotspot, I also gave them my name and my email address, and they have that information together with my IP address. Well, now that IP address certainly is personal information in the hands of this controller who has my directly identifiable information as well. So really in the case of this Wi-Fi hotspot, it's anonymous only if the data you have is otherwise also anonymous. Not if you're seeking to add pseudonymous or identifiable data to that. So again, it's really just you have to think about the context and think about context-specific analysis, asking these different questions of what are the circumstances, for what is it going to be used, and who receives it. So the conclusion here around personal data under GDPR is that the definition of personal data under GDPR is very broad and is intentionally all-encompassing. Cookies and other online identifiers are explicitly called out as examples of personal data in the GDPR, unlike in the previous Data Protection Directive. We also know that pseudonymous data is personal data. Pseudonymization can be a safeguard, but it's important to note that pseudonymous data for the first time in the law itself is actually defined as being personal data, something that not everyone has always thought of as being the case. And I think the biggest takeaway from this entire presentation for you is that it's highly likely that the data processed in the ad ecosystem falls within personal data. So remember the question, that I posed earlier of, isn't the whole point behind OBA to single out, to be able to target an individual? And if that's the case, as we see from the definitions that we looked at from GDPR, that's personal data. So it's highly likely that the data that you're processing in the ad ecosystem is personal data. If you're not sure, given the significant fines in GDPR, it makes a lot of sense to err on the side of caution. But remember that when you're asking the question of, is the data collected by your company personal data, you really need to do a context-specific analysis. It's really a case-by-case analysis. And when you think of the IP address example that we talked about a few minutes ago, it shows you that the same type of data can actually be, personal data, pseudonymous personal data, or anonymous data, which is not regulated by GDPR, just depending on the context, depending on the controller, what it's going to be used for, what other data that controller may have access to or may reasonably have access to. So we're going to turn to questions, but before we do, I'll just point out that, as Chris mentioned in the beginning, IAB Europe has a working paper on the definition of personal data. I highly encourage you to read it. It contains a lot of the same type of information that we talked about today, but goes into a little bit more depth and has a lot of helpful references for you. So I'd encourage you to go onto the IAB Europe website and take a look at that paper. And then I'd ask Chris if we have any questions.
Yep. Okay. So thank you very much for that. So we have about 25 minutes now for people to ask questions. If you don't know how to do that, there's a Q&A section on the WebEx client where you can type your question. I'm not sure if you can see other people's questions, so there might be some duplication. But what we'll do is that I will read them out since we have a few too many people to let everybody speak at once. And I'm just going to get started with the first question that came in very early in the presentation. So apologies if it's a bit repetitive, as I think it has been answered to some extent, but there's one part of the question I want to address as well. So this question comes in from somebody called Hubert Gall, and it asks, what about cookies? Are they personal data? And if yes, how to solve it, I guess, how to comply with the GDPR? And then there's the second part of the question, what about the e-privacy regulation?
Okay, those are fantastic questions. So the first part was, what about cookies? Is it personal data? Let's take that piece first. So cookies generally contain a cookie ID, and so that cookie ID would be an online identifier. The way it usually works 9 times out of 10 for companies is that they set a cookie, and within that cookie they'll set some random identifier, and that random identifier is unique to the cookie. So it's a random made-up number, but it's unique to that cookie, and that allows whenever that browser comes to a website that has a pixel or a tag from that operator or that third party, whomever that is, that allows that operator to read the cookie information, including the cookie ID. And since the cookie ID is an online identifier that allows the tracking of that browser across websites, then the chances are, as we've talked about today, that's going to be personal data. Now remember, I mean, as we said, it's always going to be a context-specific analysis. So, you know, could there be a case where a cookie is not personal data because there is no unique identifier in the cookie? Maybe it's the same identifier given to 500 different browsers. Maybe there's no IP address contained in the cookie. So could there be a case? Yes, there could be a case, but based on the way that our ecosystem, the ad ecosystem generally works, I would say as a general statement, yes, it's going to be personal data. And so the second part of the question, if yes, how to solve it regarding GDPR, and what about e-privacy? So GDPR, remember, talks about needing, if you have, so today in our webinar today, we talked about really the fundamental question of, do you have personal data? So if the answer to that question is yes, then your next question is, what is your legal basis for processing that personal data? And there are a handful of legal bases under GDPR, but the two really main ones are legitimate interest and our consent. So you as a controller or processor would need to have either a legitimate interest in processing that data, or you need to have consent to process that data. Those bases are, you know, equally there under GDPR for you to use, but I think you've highlighted the question of what about e-privacy. So e-privacy, I'll assume everybody knows, but maybe just to touch on it in case anyone's not familiar with e-privacy, the existing e-privacy directive is the current cookie consent law. That's the one that says that prior to setting a cookie, you have to get consumers' consent. Under the data protection directive, prior to the GDPR, that's been treated as an implied consent. Under GDPR, we know that consent, again, not the topic of this webinar, but we know that consent is no longer, implied consent is no longer valid under GDPR, so we're moving into a new paradigm of consent, which takes a more explicit action. And so we have the existing e-privacy directive, then we have the draft e-privacy regulation, which is not final yet, it's still in draft form. That would require, similarly require consent before setting a cookie or accessing information from the device. So what about e-privacy? E-privacy requires consent. So in answer to your question, if you have personal data in the cookie, you'll need consent under e-privacy, but I'll note that e-privacy actually isn't triggered by whether or not the data is personal. E-privacy is actually triggered by whether or not you're setting a cookie and accessing information from the device. So where this webinar, we really focused on personal data as the fundamental issue under GDPR, and we know that GDPR, if you have personal data, you can use consent as a basis for processing that data. E-privacy, if you have a cookie and you want to set the cookie, whether it's personal data or not, requires that you have prior consent.
Okay, thanks. So the next question, I think, has kind of been covered by that as well. As all data is personal, so it's a question from Oliver Gertz. If all data is personal, how can we continue working with cookies and OBA? So I think you kind of covered that already in the sense that it's not illegal, but it does mean that you have to follow the rules of the GDPR, which are very extensive. Right. And if you're not up to speed on that, then I just want to remind everyone that the GDPR will start to apply from May the 25th, 2018.
Right. And I would actually say IAB Europe on your website, we talked about the personal data paper being on the website, but there's also a paper that kind of more fundamentally talks about GDPR.
Compliance, the first steps, and that was the topic of our first webinar as well, for those of you who were there as well.
Yeah, so I'd encourage you to go look at that if you're still kind of thinking about, if you're sort of new to thinking about, okay, GDPR applies, what do I do?
Yeah. Okay. So next question here is from Jan Thomas, or Jan Thomas, I'm not sure, sorry. Do you have any more concrete insights on how to assess the mobile identifiers for advertising? Can we find a way to have them not be personal data?
Yeah, that's a great question. So in the presentation, we talked a lot about online identifiers, and mobile identifiers are a type of online identifier. So when you talk about something like an IDFA or an Android advertising identifier, those are types of online identifiers. So the same analysis that we were talking about earlier with respect to personal data applies to those mobile identifiers. So it's the same issue of under GDPR, you need a legal basis to process those, so to collect those and use those. And so it goes back to the same thing we were talking about before, and this idea of singling out. And if you're using that online identifier to single out, if it allows you to be able to track an individual device across, across apps or however else you're using it, if it's allowing you to point back to an identified or an identifiable individual, then it's likely to be personal data. So it's the same analysis.
Okay. Next question comes in from Marilia Silva. How does this impact the dynamics of programmatic? Yeah,
that's a great question. So programmatic generally relies on online identifiers. I mean, the way that our advertising ecosystem works now, there's a lot of cookie syncing. So companies setting cookies with unique identifiers that they use to track an individual across various websites, and then syncing between companies so that they can understand, when an individual, when they can match the cookies so that they understand who the individual is sort of across both companies, and so that they can come and talk to each other in the ecosystem and enable them to serve the right targeted advertisement to the right person. Again, it's the same analysis here that we've talked about in this webinar with respect to personal data, because it's using those online identifiers, and those online identifiers now falling under the gamut of data protection law. If they didn't already, which again, some would say they did and some would say they didn't, but now they're very clearly identified as personal data within the GDPR.
Okay, we have a few questions from Ursula Salawa, but I think it's in the interest of being able to answer to everyone. I just want to touch on one of the questions that she asked, which is, what will happen with newsletters and subscriptions made before the GDPR? So I guess the question is kind of asking about the timing, so data that has been collected before it enters into force. How do you do this in a way that is safe or reasonable if you weren't anticipating that it was going to be personal?
Yeah, so what I would say is that if the consent that you used previously meets the GDPR standard of consent, then you're fine because you've obtained the right level of consent. And in this webinar, we're not going to go into the specifics of what's required for consent, because I think that'll take an entire hour at least by itself, and I think that's probably the focus of the next webinar that IAB Europe is planning.
That is correct.
But so what I would say is that if the consent you've collected meets the GDPR standard, then you're fine. If the consent you've collected doesn't meet the GDPR standard, then you're going to need to get new consent to be able to meet the standard.
Okay, so I have a question from Natasha from Index Exchange. Thanks for the informative presentation. Will a version of the deck be shared after the meeting? Yes, that's the intention. I'll send a follow-up email to everyone that was invited, that joined the webinar, hopefully this week. And then in future, we will also be putting it on our website, so you should be able to see both the deck and the presentation again. I have a question from Jonas Fried. Does the right to be forgotten in conjunction with randomized unique identifiers or cookies affect how ad platforms need to store their raw data? That's a very big question. Seeing that there are large amounts of logs to be found in scrubs, it seems like a very costly risk.
Okay, let me.
Do you want to?
Can you read that again to me?
Sorry. Yeah. So does the right to be forgotten affect how ad platforms need to store raw data?
Okay. So I think what you're asking about is if these online identifiers and randomized IDs are personal data, and then a data subject comes and asks you to, for example, delete their data, or they want to access their data, or more likely they want you to delete their data, what's the impact because the raw logs are significantly large and may be hard to scrub. Yeah, I think that could be a problem for some companies for sure. I mean, I think there are a lot of things for a company to think about when it's thinking about how to deal with that. One is, pseudonymization. If you're not already pseudonymizing, could be, as we saw in some of the language that we looked at earlier, a helpful way to protect the data. And if your data is pseudonymous to the point that you can't identify whose it is, then if someone comes to you and asks you to see the data, you don't have to ask them for further identification in order to prove their identity. Now, if they choose to give you further identification, there's language within the GDPR that indicates you can't refuse that. But so I think pseudonymization is one way to think about it. I think another way to think about it is how do you get to a place where the data is anonymous, so anonymization. So if you have raw logs and someone comes and asks to have information forgotten, you may want to consider whether you want to anonymize data and whether that's easier to do within your logs than deleting entire rows. So I think it's going to be a context-specific inquiry. And I'm going to ask the others in the room, does anybody have anything else they might want to add?
What does it say?
Work in progress. We have a
So Matthias is flagging for us it's a work in progress, and that's because we have IAB Europe has within its GDPR implementation working group, there's a subgroup that's looking at these exact issues. I happen to be part of that working group, so I have some familiarity with it. But we're looking at these exact issues of, what's required when you get a data subject access request or a request to delete. What does it mean? What do you have to do? What if it impacts, significant log files, et cetera?
Yeah.
So I think you can stay tuned for more info.
Exactly. And on that topic, I just want to, because I see another question that's come in about this as well from Andre Lima, who also asks about data portability and the deletion obligations. Which part of personal data is obliged to be portable or deleted based on what the consumer asks? So to that, it's kind of the same answer, where it's a work in progress and we're figuring it out.
I think what I would say is in the context of this webinar, the first question is with personal data? And if the answer is yes, then yes, these obligations under the GDPR apply.
Right.
And we are, as you have heard, we are working on figuring out what that means exactly. So for the moment, we can only say, yeah, you probably have these obligations.
Right.
But what exactly you have to do, we're trying to figure out. And
Yeah.
It'd be great if you wanted to participate in that as well.
Right, because there is an ongoing working group, which I think the expectation is that there will at some point be a working paper that talks about this very information, and then there will probably be a webinar as well.
Yep. Okay, so I'm going to combine these next two questions because I think they're quite similar. So the first one comes in by Paul Dunny, who asks, if there are unique identifiers in your cookies, how or who would you agree a data protection agreement with for this? I think what you mean is other parties in the ecosystem that are your partners and that you work together with. Yeah, so that's an issue which I would call a controller-processor issue. And then the next question from Fiona Davis also asks, what happens when you're using cookie-based data that you didn't collect, such as a publisher has gotten consent and you have bought the data from them? This is usually where pseudonymous data is used.
Yeah, so I mean, one thing I would mention is that GDPR applies to controllers and processors. So while the data protection directive only applied to the controllers, GDPR changes that and applies to both. So the way I think you should think about it is if you are processing personal data, whether that's as a controller or a processor, you have these obligations under GDPR. You have to have a legal basis for processing that data. So, I mean, I think...
So it depends, right? Whether you are a controller or a processor, which if you look at our first working paper on getting ready, you should figure out, are you a processor, in which case you just follow on the instructions of your controller, and that will be set out in the data protection agreement that was mentioned in the first question. If you're a controller, which means you yourself determine how data is processed, then the obligations of the GDPR apply to you, or rather, you need to figure out how to comply with them, and you know, you do, you do all that stuff.
Okay, I'm going to quickly answer this. Another question from Oliver: will we provide guidance on how to get consent? Yes, that's our plan. So stay tuned for that. We hope to have
on my desk.
Yeah.
I'm a little late, I'm sorry, but it's super almost ready.
Yeah. So I'm going to another question here from Jacob Bach. He asks, actually points out that in the German IP case, the website operator in that case was the German authority, so they have different means to get an ISP to expose the identities behind an IP address. Whereas a normal company wouldn't have the same kind of access, and you just asked, have we considered this? And I think that goes back to this notion of context-specific analysis.
Right. It goes back to that, exactly. It's always a context-specific analysis. And remember that you're very right in the background that you point out. Remember that in that case, the court said that this website operator had a legal means to get this information. So again, remember we see the language in the GDPR talking about, you know, all the means reasonably likely to be used. So it's, you know, in the Breyer case, that using the legal means of going to court and getting the information was reasonably likely for that website operator to use. And in the case of, you know, your company, you'll have to consider all the means reasonably likely to be used.
I just want to offer another example of what has happened in Germany in the past. I think it's since changed, but back in the day when piracy of MP3s was running wild, German law firms have filed lawsuits against unknown based on IP addresses that they have collected, which has then compelled the prosecutor to go to the ISP to figure out who they are asked to prosecute. They would then find out who these people were and then drop the lawsuit, by which time the identity of these people was known, and the law firm could pursue civil action against these people based on the IP address. So that would be another example where there is a very indirect way to get to that information, which is similar to that case, but not necessarily, you know.
And I think just one thing to point out in, taking a step back, what I think you see from this entire presentation, from the sort of the comparisons we've made to the Data Protection Directive, some of the Article 29 Working Party opinions, the Breyer case, I think what you're seeing is that there's this trend towards personal data really being an all-encompassing term. In other words, more often than not, the data is going to be found to be personal data. And so I feel like That's the direction that we've seen regulators take. It's the direction we see in the GDPR. It's the direction we see in the courts. So, I would just point out that's a trend, and which is why we said earlier, if you're in doubt, it may be prudent, given the significant fines, potentially at issue here, to, err on the side of caution and err on the side of the data being personal data.
Okay, so we have about 5 minutes left. I'm seeing a lot of questions about consent, and I'm very sorry, but I think we're going to have to skip those because it's a discussion that once it's opened, it's very hard to stop talking about, and we don't have much time left. So I just want to address 2 questions together which talk about retargeting. The first one came in from Russ O'Connor, and the second one from Sinead Corain. That question asks, if you work for a company which runs retargeting and prospecting campaigns with cookies, IP addresses, etc., what does the GDPR mean for you and your customers? And the other question from Russ O'Connor was, what are the ramifications on retargeting?
Yeah, so I would say maybe more broadly to the first question first. What does GDPR mean for you? It means that you are now likely to be, the data that you collect is very likely to be personal data, and you are now regulated under European data protection law, where you may have previously taken the position that you weren't regulated. So remember, we talked about the concept of pseudonymous data and how most players in the advertising ecosystem, when they're looking at prospecting and retargeting, are using randomly assigned unique identifiers, these cookie IDs, or IDFAs, or other IDs, to enable them to prospect and retarget. So to enable them to single out this individual without being able to directly identify the individual, but to allow them to single out and follow that individual around so that you can build a profile, so that you can effectively retarget or effectively build a model that allows you to prospect. So now, what we're seeing, as you've heard today, is that is personal data that's regulated. So what that means is you need a legal basis to process that information, and that legal basis is likely to be either legitimate interest or consent. And it's what you'll have to do is figure out for your company, because we haven't talked about legitimate interest and consent, because those really are a topic for another day, because we could take an hour on each of those subjects, individually. Mm-hmm. So it's going to be up to your, but legitimate interest is also a very fact-specific contextual analysis. So it'll be up to your company to determine, do you have a legitimate interest? Do you need to collect consent? To also consider the e-privacy directive or regulation, and to consider whether you need consent in order to set the cookie and collect data, access data from that device. So I think, and then to the second question of what are the ramifications for retargeting, I think it's the same answer. It is very likely that you're using personal data to be able to engage in that activity, and so you'll need a legal basis for processing it.
Okay, we're coming to the top of the hour now, so I think we'll close it there with just one last question that I want to address by Paul Childs, who asks, do you think companies should have a GDPR seal of compliance to support working with partners? And I just want to say, first of all, that while it sounds like an attractive idea, it's something that you have to be very careful of at this point in time, before the GDPR is in application already, when companies promise you a seal of compliance, because in a legal sense, there's no way to know certainly if you're fully compliant or not before the law takes effect. And I just wanted to spread that message. Do you have anything final to add, Geeta? Or?
I guess parting thoughts would just be the thing that we've come back to repeatedly, which is that for the companies that are in this advertising ecosystem and who in the past have considered that they did not have personal data, perhaps because their data was pseudonymous and that they perhaps were not regulated under the Data Protection Directive, I would say the GDPR is a whole new world. As we've seen online identifiers are explicitly called out as personal data, and so you should, consult with your lawyers in your company or outside of your company, because more likely than not, the data that you process is personal data, and you'll have to think about how to comply under GDPR.
Okay. Thanks a lot for everyone who joined. Please keep in mind that we're going to continue these GDPR webinars. There will be one more, I think, later this month. We'll announce that soon. And then we'll continue again in 2018. So just remember to keep an eye out for that. And if you found this interesting, the next topic will be consent, as we mentioned. So definitely stay tuned. And thanks for joining.